Welcome back to another Real Estate Note Show. I'm your host, Dave Putz from JKB Holdings, and today we're talking about collateral review. But before we get there, my co-partner, Mr. Nathan Turner. How are
Hello,
you?
hello. Doing well, doing well. How about you?
Good, man. I hope you're getting this heat streak, man. This weather in Jersey, we're 96 today. Holy goodness. It's a good day to sit inside and look at tapes of notes, that's for sure.
We're on the opposite side of the country, and so here, 19 Celsius. So what's that? Maybe 70?
Yeah. So you're cool, relaxed.
Nice
Yeah.
and cool. Everything's great.
Oh,
Very
kid.
happy.
To me, I had the kids stuck inside doing whatever they're doing on technology today and being that parent going, okay, just keep yourself busy, stay out of trouble, right? Don't go
I
in the
went for a run this
pool.
morning. It was
Oh,
beautiful. Sunshine.
nice.
Excellent.
Nice. Yeah, I did bike ride earlier just before it get too hot, right?
Yeah.
So before we get talking about today's topic and bring Dan on, how's an open business been for you?
Been good. Been good. It takes a while to catch up after doing DME stuff, and
Yeah.
that's it's a lot of preparation going on into it, and then some things just kind of get put to the side a little bit. And so catching up on a bunch of those things. And yeah, it's been good though.
Yeah, I had a great call last couple days with some awesome people that are either creating notes, learning to buy notes, and just kind of feeling it out. It's really interesting to hear from the spectrum of newbies to experience to those who are originating it and not understand the note buying world, which
Yeah.
is really interesting. Where newbies may not realize that there's different states and different rules and all that stuff. And then they don't realize that the note community is so small, and they realizing that we all know each other.
Yeah. There is a lot to learn, and that can
Yes.
seem overwhelming at first. And so you can go one of two ways. Well, three ways, I guess. You can just give up and say, nah, it's not for me. You can learn the rules and figure out how to do it and then go ahead and do it. Or you can
Yeah,
partner with somebody.
absolutely.
So there's different ways you can approach it, but there's
Yeah.
not really a right answer, I want to say. Just keep doing what you're doing.
Yes, absolutely. I was talking to a note creator today, and we were discussing the fact of creating a first and second and how that can really benefit him in selling the note.
Yes.
That listen, you don't got to sell, 100% of a, asset. Sell 70% by creating a first and second. It was really interesting how they never thought about that because they just sold it at a really good yield and expect us to be able to buy it. And they
Yeah.
didn't realize the other side of it of being, hey, if we get to foreclose in this, where are we at in that process? Where's our thought process?
Yeah. What if? What if? And
Yes.
that it's a great strategy. I remember way back when Corey, my old partner, now we figured that one out and we went, wait a second, we could do a first and a second. Oh, that's
Yeah.
brilliant. And yes, it is. It is brilliant. And we
Yes.
should do that.
Yeah. So it's amazing that we all talk about this stuff and realize the fact that we got to network more. Every time I turn around speaking to people, we have a private call, and I'm always learning, and it's amazing. Years later, what we're learning is just amazing. Um,
Mm.
in the note business, what have you been seeing recently in your portfolio? How are things going in that portfolio world? Are you seeing performing BKs, defaults? What are you seeing recently?
I have not seen a lot of defaults.
Okay.
I have seen more tapes that are scratch and dent, which is interesting. So that starts to show some of the cracks
Yeah.
that are starting to come up. How about you? What are you seeing?
Last 3 months, we got 4 defaults, two just reinstated, thankfully.
Okay.
Another two are behind in BK. Little weird stuff going on. And I was listening to someone we met over at DME that came for an interview with you guys. And I was listening to a show she did, and she was showing the fact that there's a lot of debt in the world, and the fact that the banks are jumping on the second market and
Yeah.
creating seconds and really stealing the equity, not stealing, but offering to give equity to people who have equity just so they can afford their bills. And the fact
Right.
that the groceries adding up. So they need to take out the second on the equity and kind of take money because they have no money in their bank account. And that part is scary to hear about.
Yeah, that's really interesting. And that's setting everybody up for a lot of,
Yeah,
hard times coming ahead.
yeah,
So it'll be interesting to see. We were
yeah.
talking about her. I'd like to have her on the show at some point.
Yeah,
She's
absolutely. Well,
very knowledgeable.
definitely.
She's been around.
Yeah. yeah, she's been different from the high level to low level, and
Yeah.
she was really interested in at the DME to see what our level's doing and talking and feeling and all that stuff. She was amazed how many people were expecting the continuation of what's happened the last 4 or 5 years of
Yeah.
things are smooth, everything's great. It may not be as great as we thought it may be.
Maybe. So real quick before we get our guest on,
Yeah.
one of the things she's asking, and I had a really hard time with the question, is how big is the secondary mortgage market?
Hmm.
And I was like, oh gosh, hundreds of millions. I don't know.
Yeah. Yeah, absolutely.
It's massive, but
Yep.
I don't know. It's a big
Yeah.
number.
And we have to define what secondary is, right? Outside the government agency, the Fannie and
Yeah.
Freddie and stuff like that. And that a lot of it is in the hedge fund world, but there's a lot of people our level or one step above that are in there. So how I see on Facebook saying billions.
I
Yeah.
probably yes.
Yeah. It's nuts out there. So I totally agree with you guys that, collaboration, understanding that there's a lot of opportunity out there coming about, and the fact that people are probably going to start over leveraging themselves similar to '05, and not because they want to, but because they can't afford their bills.
Right now. And
Right?
that's different than in '05. Back then, I
Yes.
think it was more greed driven. Now it's like
Yes.
just trying
Need
to get
driven.
by. Yep.
Yeah. So I'm hopeful that we can kind of be aware of that, and stress that just because things look good now, don't expect that it will not go well in the future, and don't buy notes or create notes with the expectation that it's here to perform forever.
Mhm.
This may trickle into a spot where the property start losing value. We don't know if that's going to happen, but it could, and you have to be prepared for that kind of stuff.
Yeah.
Yeah.
Yeah. And you and I, we've talked about this before. We're
Yeah.
probably a little jaded where everything you buy is
Yes.
going to default. Everything's going to default.
Yeah. Yeah. Our first
That's
10
what we
years
came up
doing
through.
it, it is what it was. And I'm
Yeah.
sure we'll go back to that, right? I'm sure we'll go back to faults. The cycles will continue.
Yeah.
So just to remind everyone, I'm switching over. Our available assets are still available. We just add like 15 or so on there. And we'll be getting into our website, so it's not strictly on Google Sheets, but it will be available. So let us know if you have any questions about that. We're just transitioning to that. We will be kind of slowing out a little bit for our show for the summertime, just because summertime, right? And we're going to be doing some shows here and there, but I don't think we'll be doing bi-weekly, but that's okay, right?
Kids and travel and all
So
those things.
yeah, and just spending some time with everyone is the key here, right? So
Yeah.
awesome. Well, without further ado, let's bring our friend, Mr. Dan Berm. How are you, man?
Doing great. Doing great. Fresh out of court this morning. So a much friendlier audience. So I'm happy to be here.
Oh, hey,
Yeah, I would say we're jealous, but
There you
Hey,
go.
there's the
There you have
swag
it.
right there. Nice.
oh, that's awesome.
Yeah.
So Dan, this world of collateral review, and we talked off air before, I guess a month or so ago, and I was, I always go into mindset that I don't know everything, but I felt pretty good about my understanding of collateral review. And I think the first thing you shot me, Nathan, we said, "What?
Yeah.
Wait, what?" Like and I was shocked and amazed of I didn't know about that. It seemed sensible, but I think what you said was perfect, was that, you can play the defense attorney and know this stuff and really get us in a bind and get us in a big thing. But before we dive into that, give us a little background on who you are, how'd you
Sure.
get involved in the creditor rights stuff, and how you got to become an attorney.
Yeah. So, well, how I got to become an attorney, I was a very bored sales guy for a plastics company. And I decided, I wanted to kind of scratch the itch and go to law school. So 6 years after graduating from undergrad, I don't know what I did right, but I got into Vanderbilt Law School. So I was a little bit late to law school, but graduated in 2007, took a job with a large firm in Ohio. So I started my practice in Ohio. And it was right around 2009 when the bottom started falling out of everything.
Mhm.
And our law firm actually let go like 20 people. And it was a law firm that had been in existence since the 1800s and never laid off anybody. And
Wow.
so there I was. And so I was like, well, I've been in sales for a long time. I could probably go out on my own. So I did. Went out on my own. By happen chance, I got connected with a note investment fund who wanted me to cover some of their summary judgment hearings in Ohio. And following that, they said, well, we like what you're doing. Will you take all of our Ohio work? So in 2012, I started my foreclosure practice focusing on Ohio defaulted seconds. So there was a lot of seconds in the marketplace around then. A lot of large funds were buying them up and then doing training or education sessions. And then the students would then pick up the notes, learn to work them, and then they'd buy more notes. And so there was some low hanging fruit there. So I got into doing foreclosure work, sort of cutting my teeth on sort of the grimy, hairy, nasty second mortgages. Not like some others, some folks who start doing the like the Fannie Mae loans, sort of firsts, and the collateral's pristine. And they just sort of stroll into court like, no, got no problem, and they foreclose. And so I had to kind of scrape and scratch through all the problems of collateral to get to a foreclosure a lot of the time. So, but I found that I liked it. It gave me an opportunity to sort of combine my business knowledge with litigation.
That's cool.
And I got to help small business owners and investors in the process. So that's sort of me in a nutshell. Yeah.
And seconds are an interesting.
Yeah.
Well, they have always been because not all seconds are created alike, as you know.
Right. Yeah.
Some are, some are fixed interest rate notes, some are adjustable, some are HELOCs, or so you're trying to figure out sometimes whether the payments have been applied right. Have you calculated the right payoff amount? A floating interest rate. So those are some of the things that present themselves in that second marketplace.
And I know a lot of people chasing the seconds and just say, oh, they're real easy, just great returns.
Yeah.
There's a lot of gotchas.
Yeah. And then what took you to Tennessee after that?
Yeah, good question. So several of my investor clients when I was in Ohio asked me, hey, can you help me in Wisconsin? Can you help me in Minnesota? Can you help me in Massachusetts? So I just started getting licensed in those jurisdictions as time went along. So I got licensed in 7 jurisdictions now, and Tennessee is one of them. We came back to Tennessee really more of a lifestyle choice. It's funny, Tennessee is not really a hotbed of foreclosure, but the foreclosures that are done here are very easy and quick.
Yep.
Which is nice. I guess it's sort of hard to say in your backyard, you wish there were more foreclosures to do, but a lot of my work still is in Ohio, Illinois, Wisconsin, Massachusetts, but I get to do it from here in Tennessee, where we sort of created a home while I was in law school here. And then we just decided to move back because, just like this, just like we're doing now. This is how I interact with my clients. It's phone, it's Zoom, and increasingly courts too. So I really don't have to be in a particular place. It's just a good place to live.
Absolutely.
Yeah. That's nice.
Absolutely. So you got shift gears, you're in the space like that, and you really focus on being a creditor attorney. But there are times where you flip roles, right? You go on the debtor side.
Sometimes, very rarely, if we have a client of the firm who is having a difficulty. I can think of one in particular where a client and a friend here in Williamson County had some trouble with a builder who had a mortgage on his property. And the builder, when he owned the property, he had a mortgage to a first mortgage. So there was some difficulties there. And so I actually did sort of step in the role of the debtors counsel. It was really to unwind some procedural things that the builders had maybe let's say take some liberties. For instance, you should not try to sell a foreclosure or a property of foreclosure in the wrong county. So that was one of the things. But those debtor side things are really few and far between. I do a lot of other non-foreclosure litigation though, both on plaintiff side and defendant side. So
Makes sense.
that keeps me sharp in other ways.
So with that said, have you guys seen an increase of defaults and foreclosures or decrease recently?
Or bankruptcies.
Or bankers? Yeah.
It's a good question. I think, can I
Gut
say
feeling.
I'm anticipating a wave,
Yeah.
maybe not a wave, maybe a small wave, not a tidal wave. Maybe the tide's coming in.
Yeah.
Some of the stuff you guys talked about already, people are borrowing money against their home on, these pre-approved, hey, you're pre-approved for $40,000 to pay for your needs. And when that runs out and they're borrowing at these high rates, I think something is going to be on the horizon. We're not seeing it in sort of our incoming files yet. We are seeing more land contracts for deed that are moving around in the marketplace, which create some really interesting, I wouldn't say challenges, just interesting pleadings, interesting title curative issues sometimes. I don't know if that answers your question, but it's,
Are you seeing subject twos and wrap notes a lot at all? Or are you getting involved in that or have an opinion about that?
It's not something that's really presented to our firm that much.
Okay.
I mean, I would welcome it. I'd be very happy to look at that. We're mostly busy right now unwinding on the tail end of a good pool of HECMs, second or reverse mortgages that we got.
Yep.
The land contracts, and then we have some traditional first. But no, I mean, am I open to doing the work? Yeah, we're just not seeing a big flow into our firm right now.
Gotcha. Have you seen owner finance paper written not so well?
Yes.
And what are some of the biggest issues you've seen in owner finance paper that written incorrectly?
So common things even.
And why does it matter if it's written incorrectly for those who are new to the show?
So when I think of seller finance paper, the stuff that we're seeing a lot is we're seeing land contracts or contracts for land contracts is what they call them in Ohio. So I tend to fall to that, but it's contracts for deed.
Yeah.
That carry with them a note. And I don't know that in every state that's wrong per se, but I do think in some states, you're going to have some courts, when it gets litigated seriously, balk at that a little bit. So I would say be very careful when you do that. I understand why you would want to do that. You want a promissory note that you can enforce. And you're looking for a way to secure that promissory note with an interest in the mortgage or in the property. But a land contract is actually intended to be a glorified rent to own.
Yep, lease option. Yep.
So, and even in the enforcement of that, most states have a threshold where below which it's a forfeiture action like an eviction, but above which, if there's more equity paid or they paid over a longer amount of time, then it's an actual foreclosure.
Yeah.
I worry sometimes about the homemade drafting of those contracts. Most states, fortunately, give you a statutory form for a contract for deed or a land contract.
Wow.
So I would love to sort of be on the front end with some investors who are looking at doing the deal and kind of consult and advise. Hey, let's look at how we want to do this in Tennessee or South Carolina. I'm not licensed there, but my associate is, but we have a lot of work there. How do we want to structure this sort of deal so we can get you security and get you a promissory note?
So let me get technical for a second, because I agree with you. Going way back when I was doing land contracts in Ohio, and I wouldn't do a note because I'm like, it didn't seem appropriate to do both. So, and then when I sold just that land contract, then they're asking for allonges, and I was like, but there's no note.
Right.
So why would I give you an allonge for a note that doesn't exist? And I always thought that was so weird. But I was like, sure, I'll sign it for you if you'd like. But
well, the great thing about a land contract is you own the property.
Yeah.
So I mean, so it sort of seems a little circuitous to try to then loan money and get an interest in a property that you already own. I mean, you are already
Mhm.
secured.
Mhm.
Sure.
Because when you bought that land contract, you should have, I guess there's a feasibly a way to do it differently, but you should have gotten a quick claim deed of the property to you.
Yeah.
Then you have assignment of rights under the land contract. So you are now the assignee of the vendor of the land contract, but you own the property too. And if they don't pay you under the land contract, you can either, make them forfeit it, or you foreclose.
Well, that's
So,
interesting. I don't think I ever did that assignment of rights, but that makes sense.
well, I think that's what a lot of people are doing when they're trying to do just an assignment of mortgage, that they
Yeah.
just take the word mortgage off of it and they write land contract or contract for deed in there.
Right.
And functionally, it's probably doing a lot of the same thing.
Sure.
Could there be a unique and a sort of custom tailored document to meet that solution? Yeah, I think so. But I also understand too that, not everybody's excited to pay an attorney for a half a day's work to do that. You've
Yeah.
got to watch, your budgeting, especially a lot
Sure.
of these bank contracts are lower value. So I don't fault anybody for making a business decision as long as they're doing it with good advice on what the risk and reward is of that.
Absolutely.
So yeah, those are my general thoughts on that. But
So we had a
Interesting.
quick question over on LinkedIn from Don McAlpin. I apologize if I'm butchering your name, but what type of title curative issues are you seeing with CFDs, and are they state specific?
so most CFDs, land contracts, have state specific requirements. Most states require in the statute that it be recorded. So one of the things I see a lot of the time is a land contract or a land contract that has a modification, and either are recorded or the modification isn't recorded.
Mhm.
It's depending on the state. Some people will say, hey, look, you as the vendor under the land contract had this responsibility to do it. And if anything in the transaction looks questionable or even is presented to the court as fraudulent, you may run into a problem.
Mhm.
Now, we're not trying to defraud anybody. We're just trying to get somebody to pay us to live in the house.
Right.
But recording that land contract up front can sort of cut that argument off at the knees.
Okay.
So I'm seeing that. I do see something that we've already mentioned to answer his question is, how are we assigning that land contract to the next guy?
Gotcha.
Are we doing that with, if we do have a true note, if it's a true negotiable instrument, then yeah, an allonge would probably be appropriate for the note, but not for the land contract.
Correct. Yeah.
Mhm.
So those are some that pop up. I'm sure there are others out there that just I'm not thinking of.
Yeah. And typically you do a quick claim, right? Is that typically how you do the transfer of the CFD?
Yeah, I mean, you could do a quick claim deed, which is probably the cleanest for you as the transferor, because what you're doing in a quick claim deed is you're just quitting any claim you have to the property. You just say, quit, it's yours, whatever I owned, you now have. You could potentially do a special warranty deed. So it's not a general warranty deed. You're not saying I warranty this property against any claims of third parties, but you might say, hey, I own this free and clear, all except for this land contract. And I do a special warranty deed. If you do that, maybe there's a chance you can get title insurance to cover the transaction.
Awesome.
Something to think about.
So let's dive into the dirty stuff here, right? Give us one scenario that most note investors think is fine and easy, that a collateral file review that goes into. But before we go there, what does collateral review actually mean in your words?
So it's something that I was asked to do starting about 6 or 7 years ago. Somebody said, hey, will you review the collateral file for us and give us an opinion? Rarely do I give a full legal opinion, but I will give some advice. I'll point out some red flags when people come to me and ask me to do that. So when I think of collateral review, it is opening what's usually a zip file that contains everything that the seller of a note is presenting either for review by a potential buyer or to the actual buyer what they have. They've got usually the note in there, or whatever the obligation is based on, land contract. They've got maybe a copy of the deed, maybe they've got an old title report. They should have a copy of the note and the mortgage at minimum, with assignments and allonges that assign that mortgage or transfer that note. Love to see a payoff statement and a payoff history, if I can see that, and then the servicer transfer letters. So
Okay.
that's sort of the package deal that it would be great to see. Usually about half of those things are missing, right?
Yeah.
So you know, that's the business, right? You're going in and you're trying to evaluate, what do I have? What can I ask for? And if my seller doesn't have it, where do I go to get it?
And why does it matter to have those items? What's the, you know, I'm playing the
No, it's a great question.
What if I don't have this stuff? So what?
Yeah. Who cares?
So who cares? So that's the great question. The court may care if you're trying to enforce it. So what you have to do when you go into court on a foreclosure matter, or you do a non-judicial foreclosure, you're representing that you have standing. The standing is a legal term of art, means you're the right person to be enforcing this interest. You have standing to foreclose. You can't establish standing if you don't have rights to enforce the note or rights to enforce the mortgage. And each state has a little bit different definition of what's required for standing. So that's the first thing. You have to establish your standing to foreclose. The second thing is, you might have standing to foreclose, but you might not know how much is due. If you don't know how much is due, are you going to be comfortable going forward? Is your attorney going to be comfortable going forward on a homemade calculation on a napkin? Sometimes the napkin calculations are better than some of the others I've seen. But are you going to be willing to go into court and swearing before a judge that this is the amount that's due? Because we all know if you get that wrong, then the debtor can come back on you for consumer law violations.
Sure.
Those are some of the red flags. That's why it matters. The other reason it matters, I think, mainly to your audience on the front end, is it helps you value the amount of the asset, right?
Yeah, of course.
So if you look at it and it's missing a lot of stuff, are you going to have to pay somebody like me, you know, 4, 6, 7 hours of work to fix that so you can then go enforce it? Or is it pristine? If it's pristine, then you don't have to pay me to do any of that stuff. We can just go right through the process. So those are some of the reasons. Those are some of the whys why collateral review matters. But in my world, it's really about avoiding the red flags. Before we go into court or before we file for a non-judicial foreclosure, do we have all our ducks in a row, or are we going out there risking an FDCPA claim or a state law claim?
I also make sure when I send over that kind of stuff, the O&E report, is in there, because it shows the chain of recordings in the county records, just so that the attorney can see the quick chain and say, yes, 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 yes. Whoa, why is this missing? And that kind of stuff. So I had that in there.
And we've said this before, but I'll get your take on it. Most things are fixable. It's just going to take time and money and effort.
I think that's right. I've had one where, the mortgage was gone and the note was gone.
Wow.
Missing or released?
Gone, the missing. So, and no lost note affidavit. We just, had some very bare bones information that we could say, okay, well, there are mortgages and assignments of record. So we tiptoe into court and we do a quiet title and declaratory judgment action. We're not seeking to, foreclose. We're not seeking to collect. We're seeking to just clean up the record. Now, this was in Massachusetts. You got to do that first before you go to land court and you foreclose non-judicially. But we did that, and funny enough, nobody could understand why we were there. Everybody thought we were trying to foreclose, and we're like, no, we're trying to fix things. Well, we got the declaratory judgment that the note existed. Here's the amount that's due, and our client was a party entitled to enforce the note. We got the quiet title action that the mortgage existed. It was assigned eventually to us. And we got an order that we were able to record in the Register of Deeds that said that. So we were able to sort of put Humpty Dumpty back together again.
Wow.
And go to foreclosure. But it took a long time. It's not cheap, but it was fixable, to your point.
That's amazing.
So that's a good example of like, that's a pretty messed up file when you get that. There's no mortgage in there. That's
First thing I do is I'll skip it because I'm like, there's no way, right? That would be the first thought, or I don't want to deal with the hassle.
Unless I'm getting it for a really good price, but
you know, the good thing about mortgages is that they're usually recorded on the front end. But you know, if you're missing any assignments of mortgage, and you don't have a mortgage in the file, I mean, it can create some roadblocks, but most of the time you can get around them.
Gotcha.
So in a situation, you know, similar to that, like something like that, where it's a missing note or something like that, do you ever use estoppels? And are there any limitations?
And what is estoppel before, just for those who don't know?
So an estoppel certificate is something where another party has agreed to provide you with evidence or subordination or some other rights or proof of rights in the property. It's not something that really, not something that's come across our desk, to be honest with you. I mean,
really,
I could sit here and tell you, you know, and make something up, but I'm not going to. It's just,
and they're not common. I've only in files I've bought every once in a while, and it'll be something. So the way that I've had them in the past is, I think they do it as a matter of practice, but some people that I buy notes from in Texas, and they're seller finance notes, and before they sell me the note, they'll go and get an estoppel. So an estoppel signed by the borrower and signed by the lender, both attesting to, you know, we both agree that the unpaid balance is X.
That's awesome.
So that there's so in case you're going through and having to prove something, well, then you've got that estoppel to lean back on and be like, well, they said this was this, we said it was this, we both agreed to that point. So there you go, judge. We'll take it from there, kind of thing.
Well, I'm writing that one down because that's great. Usually I see estoppel certificates in our commercial leases that we do for our non-foreclosure clients. So you know, you're doing like a lease for a shopping center, and then the parties agree that if they ever need to cooperate to permit a new loan to be had on the property or against the property, the estoppel certificate comes into play.
That's awesome.
They're certainly not common, but I do see them every once in a while.
So let's get into the dirty stuff here, right? Give us an example of something that us note buyers may not realize.
Okay. So I used to have a radio show, and what the producer told me is, don't be afraid to keep telling folks stuff you've already told. So I'm going to tell you guys some of the stuff that I talked about at DME. So one of the things that I don't see as much anymore, but it pops up, is home equity lines of credit and allonges. So you have to understand that in order to an allonge, I'll just do it like we're all new at this, right?
Yes.
So an allonge is the document that you would attach to a note to transfer that note from yourself to the next person. It takes the place of a stamped endorsement on the note. It has to be affixed and attached to it. It's supposed to travel with the note.
So just real quick before we go there, so just imagining a check for those who are, you know, our age and older, and in the back of the check, if someone signs it, they then signed and you endorse it right below it, and that person now signs it. Now they are the bearer of it. That's exactly the kind of concept we're talking about. Just imagine the fact that instead of signing the back of the check, you're attaching a paperwork and saying, I'm now assigning it with this paperwork with that check. Sorry, Dan.
Yeah, no, I mean, personal checks and notes are in the same family. It's kind of like an otter and a beaver, right? They're in the same sort of family. On a note, on a check, you write pay to the order of, and you pay to the order of that person. And then on the back, when that person endorses it, they can then endorse it, pay to the order of David. And then David can pay to the order of Nathan.
Yeah.
Same thing with notes. You can stamp it on the note. You can create an allonge that basically says pay to the order of this next person. The reason you can do that with notes and checks is because both are covered under the UCC. It's sort of as a negotiable instrument. But home equity lines of credit under many states' rules are not in the same family. So you've got the otter and the beaver, and then you've got this like I don't know, alligator over here is the home equity line of credit. He's not in the same family. He kind of does the same thing. He swims in the water, but he's a different animal. So a home equity line of credit, for instance, in Illinois, is not deemed a note. It's not even deemed a written contract, even though it's on paper. We can talk about that later. But an allonge only can transfer and negotiate a note. You have to do something else to transfer a home equity line of credit. The reason it's different, that home equity line of credit, it might say I'm going to loan you up to $240,000, but it doesn't say I have loaned you this.
Gotcha.
It'll say you can pull down this credit line for a period of 10 years, and that's the first draw period, and then the second draw period, and then there's different interest rates. But you never really know how much you're going to pay each month until you get a statement. Not so in a note. A note tells you here's how much you got to pay each month. So the notes are cleaner. They're more like a check. They can be assigned by an allonge. Now, why do I say all this? Most of the time when I see a home equity line of credit come in, there's a stamp on there or there's an allonge, and they've just sort of said, okay, pay to the order of so-and-so. It doesn't work in a lot of cases. Now, sometimes you just put your proof on in your pleading. Foreclosure case, here's our home equity line of credit. Here's our mortgage. We say this amount is due. We've attached all the documents. It might include allonges. If nobody asks, if the borrower doesn't raise a defense based on that, the judge is likely going to go ahead and grant you judgment. But, the minute you say that, the minute you feel comfortable about that, you're going to have a clever borrower's attorney come up, and he's going to have done his homework, and he's going to try to knock you down. So you may have to do some other pleading in that complaint, like I mentioned earlier, like a declaratory judgment action to say, hey, look, I got this home equity line. I should be deemed the right person to enforce it. Judge, in addition to my foreclosure counts, give me declaratory judgment that I'm the right person to enforce this. So there are ways around it, but that's something that a lot of people, it's a pitfall. You think you've got everything lined out. You're feeling really good. You've got allonges from the first person through all 5 assignees. And then you might not realize that those might not be as effective to transfer that home equity line to you as you thought.
Is that something that could come up, like the HECM loans that I've bought, the home equity conversion mortgages? I've only ever bought non-performing, and the reason they went non-performing was because the borrowers passed away.
Right. So
I haven't had that argument, and I hadn't ever thought of that, but I see where you're going.
Right. So it's an interesting question. It's really not come up in our firm that we've had a collateral issue with HECMs. HECMs are reverse mortgages. The interesting thing about them is that every HECM loan has 2 mortgages. Mortgages, because HUD comes back in and they secure and have a mortgage the property in the event that the first mortgage, the lender has to make a claim against HUD for reimbursement. So there's that. Most of the time, though, it's a good question because it is sort of a home equity loan.
Yes.
I do think that it's going to be hard to get a state court to say that the way HUD or the original lender acting under the federal statute has assigned their notes and mortgages to the next person is going to be ineffective under state law. I think I could make the argument that the federal law trumps the state law. It doesn't mean to be sloppy with your HECMs, but at the same time, I think there are some more protections built into the HECM circumstance than with standard home equity lines of credit.
Interesting.
Interesting. All right.
So what other scenarios do you see that we have to be kind of watching out for, or you've seen used in the courtroom that had standing, and either you were able to be a savvy attorney to get around it, or you took note of it and said, oof, I gotta make sure I watch out for that.
Payment histories, if you're in your collateral review process and you have a payment history, that's very helpful. If you don't have a payment history, but you do have a good chain of service or transfer letters, then that can give me a little bit of ammunition if the issue comes up. A lot of times we'll see when a borrower does get an attorney, what they'll say is, hey, look, yeah, he's in default, but you can't prove how much he owes because you don't have a full payment history. It's funny what the assumptions are on the other side of the bar. So, we know that, well, a payment history is what it is. And if there's no payments, there's nothing to put in the history. And if it's been in default since, 2016 and it's changed servicers a bunch, then each servicer has been nothing for them to record. And they could record a zero, but a lot of times, especially sort of the mid-level in size servicers and below, there's nothing to really record there. They just But you have now 3 servicers that have gone by in your chain since somebody had kept a payment history. And it might have been so long ago. I mean, if this known mortgage was originated in 2005,
Yes.
2000, they might have paid for the first 5 years and then it got transferred 15 times. And then you're trying to figure out the pay history. Well, so that's why a pay history is great to have. If you don't have it, we can at least subpoena the prior servicers and say, provide us your pay history. We're way down the road and we're trying to foreclose on this mortgage. But the opposing counsel for the borrower will sometimes try to make it seem like you're defrauding the court because you don't have a pay history. When their client is sitting right there across from you and they know they haven't paid anything in 10 years, So there are ways to get around that. Nobody likes to spend the money on deposing somebody, but I've had to do that before. I tell a story that one time we were getting really kicked around on a pay history issue. And in a lot of states, there's the judges handle criminal law, they handle business law cases, and this might be one of 10 types of cases. So they're not really well versed on foreclosure law. So the judge in that case was really giving some credence to this. Well, the plaintiff doesn't have the pay history argument. Well, I deposed him and then I showed him in the course of the deposition his own bankruptcy petition that he filed where he listed the second mortgage. And he said exactly how much was due on the second mortgage in his own bankruptcy petition. And very soon thereafter, after he admitted what was due, I had solved my payment history problem because I didn't have to. I got an admission that here's the amount that was due then. And then was about 5 years ago at that point. Then I just had to do math. What's the note rate, late fees, all that kind of stuff. And then I could go to the court. We ended up settling that after that deposition, which was pretty.
I know that a lot of times we get notes, you don't get the full pay history. Nathan, I don't know if you have the same experience where you may get the last 3 years. You don't get the last 25 years of payment. And in the beginning, that kind of concerned me, but it was like, listen, you saw where it was when you first got 3 years ago, and to today, it made mathematical sense where that's where it should be if it was. So I've never had a problem with that. I see Cindy had a question. Have you dealt with notes outside statute of limitations?
Yeah, I have. It is not a great place you want to be. And I'm glad you brought that up because we're working on sort of a 50-state survey of statute of limitations. David, I know you keep some records in your files on what statutes limited, but we're going to sort of roll it out in blog posts and talk a little bit about the nuances. But it's a great question. Statute of limitations, very difficult to get around.
So real quick, what is statute of limitations for those who may not know?
Yeah, good. I'm glad you slowed me down. So each state has a period set by a state statute, after which you cannot enforce in a foreclosure action a mortgage, or after which you cannot seek payment on a note. It varies. It's all over the place, and it's always changing. Since I've been practicing, since I've been doing foreclosure work in Ohio, so 2012, the statute of limitations has come down 3 times.
Wow.
Or yes, it's come down 2 times. It started at, I think, 10, and then it went to 8. Now it's at 6. So 6 years from what's called the accrual date. Now, here's the big misconception. It's not always, in fact, in my states, it rarely is the date of default. It's not the date on which they started paying. So if you have a situation where you're looking at a collateral file and you've got a demand letter from a prior servicer that's dated 2010.
Yep.
And it says, hey, you haven't paid since so-and-so, and that's what the payment history indicates. It could mean that your time bar, could mean that you can't move forward with foreclosure on that. Here's what it doesn't mean. It doesn't always mean that the lien goes away. If the borrower dies or wants to sell the property, they may still have to clear out your lien.
Sure.
So that's the first thing to think about. The second thing is the default date is not necessarily the date on which the statute of limitations start. That accrual date is usually the date on which the loan is accelerated. If you dig into your mortgage and your note, you'll see some language in there that says, if you are in default, the lender shall send you a notice that you are in default and that you have no less than 30 days to cure your default, or the lender may accelerate the amounts due. When that happens, then you basically said, okay, this is due. And that is your accrual date for the statute of limitations in all my states, in most states I know about. So those are the considerations. Can you get around that? It's not.
And there's different states have different parameters with, I have my list here I'm looking at real quick. Is that the last payment received, maturity date, due date, acceleration, start of foreclosure, origination, under seal, judgment, and we always look at the fact that the ability to advance the due date and also the non-merger and due deed in lieu.
I'm glad you mentioned the maturity date too, because the maturity date is the sort of the adjunct to the acceleration date. So if somebody goes in default and you have, let's say it matured that next year, and then you didn't send the standard demand letter until several years later, well, there's really nothing to accelerate on maturity. Maturity is an acceleration depending on amounts. So you would want to look at the earlier of maturity or acceleration.
That makes sense.
Yeah.
Yeah. Awesome.
It can be a tough one for sure.
Yes.
And as far as like advice, talk to the attorney, because every state's just a little bit different. They're going to handle a little bit differently.
Yeah, I'm glad you said that, because everything I say today is educational purposes only. I'm not giving legal advice.
Yeah.
I should have done that at the outset.
And some states allow you to do certain things that other states don't. It is state specific. So just keep an eye on that. And laws are changing all the time, right? We've used the ability to advance due dates in Florida and stuff like that, where some states don't allow you to do that to avoid the statute of limitations. Again, speak to your attorney, make sure if you're buying notes that have a long due date that you're making sure. And if you're if you believe you're outside the statute of limitations, ask your seller what they've done to avoid it, right? Hey, they may have said, listen, yes, we sent a demand letter and we started this and this happened, which may kick the can down the curb with statute of limitations to avoid it.
One point on that real quick, because if somebody is looking at a demand letter in their collateral file and it says, and it's dated 2010, and you think, okay, well, if they sent this on January 1st, 2010, then 30 days after that, I'm started the statute of limitations period, I must be time barred. That's not necessarily the case, because look very closely at the language of that demand letter. If it says, if you don't pay within 30 days, we may accelerate the amounts due, it's a very different meaning than we shall accelerate. So if it says shall, you're probably more in danger of being time barred. If it says may, then really what you've done here is you've sort of shifted the burden on the defendant to show that somebody along that line, some servicer, actually did take some sort of internal accounting efforts or other evidence of acceleration that they can bring to bear. Now, it's not a get out of jail free card, the may versus the shall, but it is something to look at closely and maybe not give up on a collateral file just because you think you're sunk on the statute of limitations.
Well, I know we're getting to our witching hour of an hour, so we're gonna let Nathan kind of ask. We kind of hit on it before, but Nathan, what's your final question?
And I appreciate the discussion, because this is like, it's a big deal. We're buying this collateral file, so we better understand it, know how it works, and then know what some of the potential pitfalls are. So that's really good.
And why the owner finance and seller finance people need to understand why their paper has to be in line, because when we have to, or may have to, foreclose on it, if it's not in order, we can't foreclose, and you basically have a junk piece of paper.
Yeah. Even collectability, all those things. I mean, it makes such a difference. So we want to make sure it's done properly up front. That just saves us time and energy and money, and Dan doesn't get paid. So,
and we've seen all kinds of stuff out there with collateral being so bad, where start dates weren't on the actual note, right? Where the PITI was fixed. Where we've seen like missing payment amount, like all kinds of stuff has been seen on the seller finance world that just is dangerous, and they don't see it because, hey, they're paying, who cares? So
it matters.
So
we kind of talked about this a little bit, but you talked about seeing a wave coming, maybe not the tidal wave, but maybe more just like the tide coming in. What's kind of your prediction? What do you see coming up?
So it's hard to get attorneys to make predictions, right?
It depends, right?
Yeah, it all depends. I think probably, if I had to guess, the defaults are going to sort of ramp up. I think there are people who, we've already talked about it, they're needing to borrow money to meet their basic needs. Right now, it's I think it's like 11% more expensive to live than it was 4 years ago, and salaries have stayed relatively flat. So that's going to catch up. I do think, though, that from just a general real estate market perspective, there's going to be some opportunities probably in this seller financing world. You're going to have a lot of younger people entering into the home buying market. I say younger. They might be time home buyers, but they've been locked out because of interest rates and down payments. So if I was looking to place a bet, I think that the sort of the unique seller financing models will probably create some opportunities for them to buy, but also will eventually result in a wave of foreclosures. Don't sleep on the reverse mortgages. I think the reverse mortgages are going to be big for probably the next 10 years or so. Baby boomers, right now, what they're not doing is they're not borrowing the $40,000 on the loan that comes in the mail. I think they're going to start getting very comfortable with reverse mortgages. And if you get them, they're very, I mean, sometimes they carry a high price, right? But,
of course,
if you can get them, the foreclosure process is made relatively easy by the fact that you don't have any threatening borrowers on the other end. I don't mean to be coarse, but if we're talking economics, it seems like it makes economic sense there. So I don't know. I kind of danced around it. But I would love to get busier. Usually, what happens though is when the market is bad for everybody else, we're really busy.
Yes.
So, and I guess also last thing, don't discount the fact that some of these student loan borrowers are not getting the forgiveness that they had hoped to get.
True.
And, you know, they might have been sort of on, you know, stringing this along bit by bit. But if they end up, you know, not paying their mortgage 1 month to pay a student loan bill, or they go into bankruptcy, the post-bankruptcy foreclosure options will be there too. So,
Yeah, absolutely.
Yeah.
Well,
That'll
Dan,
be interesting.
we appreciate your time. If guys will have the link for get his information in the chat. If you have any questions for Dan, please reach out to him. He's really easy to talk to, very friendly. He was a DME last year. I'm sure he'll be there this year, next year. But he have a boost. So Dan, I appreciate your time. Hang on for after hours, but it was awesome information and really broke it down for a point that everyone can understand the importance of the collateral review being one of the crucial points in due diligence.
Yeah.
Thank you so much.
yeah, thrilled to help.
Awesome. Thanks, Dan.